another officer who was out of the sight of the defendant said that the missing girl's body had been found. Officer Doyle was watching the defendant when the other officer made that statement. And the defendant's hands and feet began to shake, and the defendant acted extremely nervous. Objection is made. Hearsay. And how do you rule? All right. I think I'm going to call on people just because we've never done it before. I'm going to pick on Zennia Lopez. You got an answer for this one? Where are you? All right. Okay. So, Officer Doyle is telling the jury about what another officer said. The other officer said the missing girl's body had been found, but the real heart of Doyle's testimony is his observations of what the defendant, how he reacted, what his physical reaction was. Is this even hearsay?
Yes, I think it's hearsay.
The defendants, now the other officer saying the girl's body has been found is not hearsay, because that's not being offered for truth of matter asserted. What we're really focusing on here is the physical reactions. And physical reactions are hearsay if but only if they're intended to be communicative. They're intended to be an assertion of some kind. And if they're, for example, just his immediate reaction, involuntary, maybe it's not an assertion. But this is a real easy one, because remember, every time you hear or you see in the scenario the word defendant, it's not hearsay. Even if it was a straight out statement by the defendant that the witness is testifying about, it's an admission. Admissions of the defendant, anything out of the defendant's mouth, is not hearsay. But in this case, I think that the involuntary reaction was not intended to be an assertion, so it's not hearsay anyway. And we would overrule it as not being hearsay under 801A. And also, even if it is potentially hearsay, if it's intended to be an assertion, it's something that the defendant is asserting, and of course the defendant is outside the hearsay rule entirely. As long as you're offering it against the defendant, anything he says is an admission and is not hearsay. Okay, so is that clear?
Yeah, well, it's because it's not given, because it's given to him even though it's not the witness?
I'm sorry?
Even though it's not his statement?
Well, I mean, it's his conduct. So if we're focusing on the conduct, the fact that he was shaking and stuff, to the extent that that's an expression or an assertion, it's the defendant's. So that's outside the hearsay rule. Yeah.
Since it wasn't witnessed by Officer Doyle?
Yeah.
It was witnessed by the other officer?
No, actually, though, and maybe I wasn't clear, Doyle is watching the defendant. The other officer is like in another room saying this to Doyle.
Oh, so Doyle saw it?
So Doyle knows the defendant heard him, and Doyle's purpose in being a witness here is, how did this guy react when he found out that the girl's body was found? And of course the relevance is that, there may be some guilty feeling there by the defendant, because now that the girl's body has been found, his reaction is, his hands and feet begin to shake and he's extremely nervous. So the answer here on the first problem is it's overruled. I mean, the objection's overruled because it's either an admission if it's an assertion, or I think the even better answer is it's not hearsay at all, because it's just Officer Doyle testifying about the defendant's involuntary bodily reactions, and so it's not an attempt by the defendant to even say anything. All right, a girl has disappeared. Some of her friends and family, they put up flyers all around town. Anybody seen this missing girl? Hope confronts the defendant, and Hope is our trial witness here. Hope confronts the defendant because she knew the defendant had gone out with the girl before she disappeared. And Hope confronts the defendant and says to him, "You killed her, didn't you?" and she's testifying now as a trial witness, that the defendant, when she made that statement to him, he didn't say nothing. He looked down and he shuffled his feet. The objection of hearsay is made, how do you rule? And again, what you're analyzing is the appropriateness of Pope testifying about the defendant's physical response to her statement. All right, so I'm going to pick on somebody else here. Jacob Newhart, you got an answer for this one?
It's not hearsay?
Yeah, I think that's right. I mean, he's not intending to make an assertion or a statement. Plus, again, it's the defendant, so we're okay because it's outside the scope of the hearsay rule. Because to the extent that it is an assertion, it's an admission. This is an example of what's called an adoptive admission. You look at Rule 801D 2B, and 801D 2B talks about statements that are not hearsay, and 2 is an opposing party statement. That's the admission, right? And the statement is offered, and then 2B, an admission is one that the party manifested that it adopted or believed to be true. So to the extent that this is an assertion, basically the law assumes that when somebody makes a serious accusation like this, like you killed her, that if you didn't kill her, you would say so. And to the extent that he didn't say nothing, that's the relevance of it. But it's considered an admission and it's not hearsay. All right. The defendant is charged by information with a felony, so that the DA doesn't go to the grand jury. The defendant testifies at his own preliminary examination that he did not commit the crime. At his trial, the prosecutor, in the opening statement of the trial itself, tells the jury that the defendant is going to get up and he's going to say he didn't do it, and he's just made that up. So when it's defendant's turn and the defendant's case is being presented, the defendant testifies he wasn't there. And now his lawyer wants to introduce a transcript of the preliminary examination testimony of the defendant to demonstrate that he gave the same testimony at that time. The prosecutor, of course, objects on grounds of hearsay and relevance. This is 801D1B. This is the prior consistent statement. Statements that are not hearsay include a declarant witness's prior statement, somebody that was both an out-of-court declarant and is now a trial witness. And a consistent statement is not hearsay if the out-of-court statement is consistent with the declarant's testimony and is offered by the declarant witness to rebut an express or implied charge that the declarant recently fabricated it or acted from a recent improper influence or motive to testify. So what the prosecutor did in his opening statement by asserting flat out that the defendant was going to take the stand and lie was he opened the door for the opportunity for the defense to introduce not only the actual testimony of the defendant here at trial, but a transcript to show that he had testified consistently with that before. Question 4. Now what we got, you always have to look at what we're dealing with. We got a hearing on a motion to suppress evidence. And the allegation in the motion to suppress evidence is that the cop violated the Fourth Amendment right to privacy of the suspect because he made a warrantless entry into the defendant's house. The cop wants to testify at the hearing, and again, the hearing on a motion to suppress is the judge only, we don't have a jury there. The cop wants to testify that the dispatcher told him before he went into the house that the victim had called to say the defendant had a gun and was threatening to kill her. The defense, at the motion to suppress hearing, makes a hearsay objection. How do we rule on that? Brian Simison. Where are you? Brian's not here? Oh, never mind. Can't ask him. Megan Watkins, tell me. Where are you, Megan? Okay.
I'm just talking over it.
What's that? You gonna
I'm just rereading it.
Oh, okay. You weren't paying attention until I called it. I got you. But, now bear in mind that we're one of the aspects of what is hearsay is it's being offered for the truth of the matter asserted.
Would it be hearsay then?
No, it's not hearsay. 801C2. What the dispatcher told the cop is not being offered for whether the truth of that matter. In the context of the motion to suppress, the cop is trying to justify to the judge why he thought there was an emergency and he went in without a warrant. So the fact that he was told, whether it's true or not, that the guy was holding a gun to the woman's head justifies him going in without a warrant. And that's what this hearing is all about. So that hearsay objection is overruled because it's not hearsay. It's not being offered for the truth of the matter asserted. Remember, hearsay is out-of-court statement made by declarer not testifying, offered for truth of the matter asserted. Yes, sir?
Couldn't that fall under 8036 as well? It's a
8036. As, oh, records of regularly conducted activity?
Cause wouldn't it go back to the telephone call that said he had a gun and,
Well, that would be a 911 tape, and we're getting to that in the second part of the question. Here, the prosecutor is not playing the 911 tape, he's having the trial witness say, the dispatcher said this and this and
Oh,
such, okay? But yeah, we're gonna get to that in the second part here. So it's not hearsay because it's not offered truth of matter asserted, because it's offered for a different purpose. It's offered to justify why the cop went in without a warrant. But now, the second part of the question, suppose the judge denies the motion to suppress, the case goes to trial, and the victim doesn't show up, so the prosecutor doesn't have the victim to call as a trial witness who can describe what it was that the defendant did. So now this prosecutor wants to introduce the 911 tape and just play the tape so that the jury can hear what the victim is saying to the dispatcher and what the dispatcher is saying back to them. And the defense, of course, objects on both hearsay and constitutional right to confront grounds. So how do you rule on this objection? Now, yes, it would be potentially 8036, except that all of the rules of evidence, including and particularly the hearsay rules, are always interpreted in light of the constitutional right to confront your accusers. And the U.S. Supreme Court has specifically ruled on 911 tapes that if they're being offered, and in this context, it's now hearsay because it's being offered for the truth of the matter asserted. The prosecutor wants the jury to believe that the defendant did hold a gun to the lady's head. That's the heart of the case. And since the lady's not there to testify, he wants the tape to substitute for the lady, but he can't do it because it's a denial of the right to confrontation. So both the hearsay and the confrontation objections are sustained in the second part of question 4. Question 5, we got a defendant, he runs a red light, he collides with the victim and he kills her. He's taken to the hospital, he's seriously injured, he tells the ER doctor that he ran the red light. He's on trial for vehicular homicide. The state wanted to produce the doctor, but they can't because the doctor has moved to Africa. So now they want to introduce the medical report, the business record, right? So it's basically 8036, a business record. And of course the emergency room report records the treatment of the defendant and all the statements that he made during his time in the ER. But the defense objects because of the doctrine of Johnson versus Lutz. Remember, I told you one of the limitations of a valid, admissible business record is that it's only admissible as to that portions of the business record